We're 6 years into the Innocence Projects now, and so what we wanted to do was to make a different kind of contribution today, and it's principally to walk you through this book that we've produced, supported by LexisNexis. We couldn't have done it without their support, but what it does is we're always being asked for information about why do we need Innocence Project, why can't the criminal appeal system deal with claims of innocence. How do you go about investigating a claim of innocence? What can students actually do? And it's been, I don't think we could have written this book 5 years ago. We certainly couldn't have written it 3 or 4 years ago. But what we've done today is we've drawn from our experiences over the last 5 or 6 years, and we've put together a method for investigating an alleged wrongful conviction case, which we'd like to share with you today. But even when you investigate a case, that's not the end of the story, and people can overturn their convictions, and there are still problems in terms of getting justice for people who say they're innocent. One of the things I want to say, I suppose, before we start is this book, Claims of Innocence, an introduction to wrongful convictions and how they might be challenged, is of usefulness to a range of different audiences or user groups. So we did a talk last week to a grassroots organisation called Progressing Prisoners Maintaining Innocence. And what they want to do with it, they want to empower prisoners themselves to utilise the methodology in there to work on their own cases. Because even though we've almost got 30 innocence projects in this country now over the last 5 years, with students working on cases of prisoners maintaining innocence, there are still too many cases which are coming forward which we are deeming to be eligible, so we can't work on all those cases. We've got 87 cases at the moment that are being worked on by member innocence projects in universities, but there are over 100 cases which we deem to be eligible that nobody's yet working on. So we want to kind of empower different groups to actually work on them cases themselves. Just say something about inverted commas successes. We're yet to overturn a case, but our first case is going to be the first case worked on by students in an innocence project is in the Court of Appeal between the 7th and the 9th of December this year. And we'd love people who are interested in that to come down, see Mike Mansfield in action, probably for the last time in a criminal appeal case. And to support that effort, the case is Simon Hall. If you put that into Google, you'll find out all about Simon's case. But in terms of other successes, we've currently got 8 cases which are being reviewed by the Criminal Cases Review Commission. That can take a long time. I'm going to say something more about them in a minute. We've got 1 case being reviewed by the Scottish Criminal Case Review Commission because we've got an innocence project in Scotland, and we've got Simon's case back to the Court of Appeal. We bumped into someone downstairs from BPP, and they said they're going to be able to soon report that they've got a case which is going to the CCRC as well. So there's a lot of cases on the way to the CCRC, and things are looking quite promising. As I said before I start, I wanted to, especially to this audience, you're going to be lawyers, and I don't want you to think that what we're doing today is some kind of mortal critique of law. Innocence projects are principally law students working in universities. There are a couple of innocence projects in School of Journalism, but the vast majority are law students, people who want to be lawyers, that want to work on real cases as part of their law degrees. And for the most part, the legal system as it currently stands does a very, very good job. I'm glad this is being filmed because I've never said this before in public. It does a very, very good job of overturning alleged wrongful conviction cases. There are many thousands of cases which are overturned each year in England and Wales by people who've made an appeal against a criminal conviction and overturned it on appeal. So there's a lot of great work being done by the criminal appeal system. But the problem is that whatever system you've got in place, it's never going to be foolproof. It's never going to be perfect. And the reason why our legal system is probably the best in the world is because what we do in response to cases that we can show where somebody is innocent and the existing system can't deal with that case, can't overturn that case, how it's presently constituted, it's in response to those cases that you see law reform. So there is a real law reform element to working with Innocence Project cases. So just to kind of say a little bit about that, The Birmingham 6 and the Guildford 4 cases, they were cases that the existing legal system in the late 1980s and early 1990s could not overturn. The grounds weren't there. The system had to be changed to accept the grounds that they had, and that led to the setting up of the Criminal Case Review Commission. So the cases we're working on, people who have been convicted, failed in appeal, failed at the Criminal Case Review Commission, and continue to say that they're innocent, they're the cases that we work on, hopefully to get justice for those people, but equally to try to push on to make our system even better. We wanted to have some books to give out today, and we don't, but they are going to be ready in the next 2 or 3 weeks. They're actually currently with the printers. And I just want to say something for about 10 or 15 minutes about the first 2 parts of the book, and then I'm going to hand over to Gabe Tan, and she's going to talk to you about this methodology for proving innocence. The first part, it talks about what we're trying to do is establish the problem and help people to understand the problem. So we very loosely call these chapters, but some of these chapters are only a few pages. The authorities for this book is all the previous work that we've done on wrongful convictions, and they're all cited in the back. But it's a book for lay people. It's a book for ordinary people to try to understand what can go wrong in the legal system and how you can try and put that right, as I said. So the first real chapter of the book talks about the key causes of wrongful convictions. And what we're talking about is not speculation. You know, we're not anti-system in any way. As I've tried to explain, we're about trying to make the system even better than what it is today. That should be part of our mantra. But when you look at successful appeal cases, you know, you see in real cases that people, sometimes for a variety of different reasons, not always because they're coerced by the police, sometimes because of their own personalities, they make false confessions to crimes that they didn't or could not have committed. Thinking of a case called Ian Lawless there. A case called Warren Blackwell. What happens in that case, he's falsely accused of sexual offences that he didn't commit by a woman who was named in the House of Lords because she had named several men have committed sexual offences against her, and she kept changing her name by deed poll. So when she was making these allegations, nobody knew who she was. It turned out she had serious mental health problems, and I thought there was serious problems in naming her, but nonetheless, innocent people can be falsely accused of sexual abuse. Police misconduct is another big theme in the literature on successful appeals. Police fabricate statements sometimes against innocent people. They call it noble cause corruption. They do deals with other criminals. They reduce charges against people to get testimonies against people because they know they did it. But without those pieces of evidence, there is no knowledge, there is nothing to show that they did it. In an adversarial system, as you know, it's more about winning cases than it is about justice, as in a lay sense of that word. And we know through cases like Johnny Camara that often, sometimes, prosecutors don't disclose vital evidence that might be favourable to the defence. So Johnny Camara spends 20 years in prison until 206 statements, which were not disclosed by the police, prosecution, show that he couldn't have actually killed John Suffield. A big problem since the introduction of the Police and Criminal Evidence Act, prior to PACE, and the reason why we got the Police and Criminal Evidence Act was Sir Henry Fisher, in an official report of the Confate affair, which led to the Royal Commission on Criminal Procedure, said that the police were just fitting up innocent suspects. That term came from Sir Henry Fisher. And what was happening is, you know, confession evidence is often the best evidence to have in a criminal trial if you want to get a conviction, and people were being coerced into giving confessions against themselves. Since PACE, you don't see that, but we have a different type of confession. It's like a third-party confession now. And we've got lots and lots of cases that we're looking at that the main testimony against somebody is prison grass evidence, prison snitch evidence. And so there are authorities on that. Dudley and Maynard case, these two guys spend 20 years in prison each, 40 years collectively, following a deal that the police had done with a guy who was in prison, dropped charges against him if he said that he received a cell confession. Fascinating cases that we're looking at. One case we're looking at, and I think it's interesting when you start thinking about this, because people are supposed to go into prison on remand because they are, charged with serious offences, murder, rape, violent assault, whatever, and they're said to be a risk to society. But in some of the cases we're looking at, there was no evidence prior to them going into prison on remand. So I don't see what the justification was. The only thing seems to be that they get put into prison so that then you can manufacture evidence against them from prison grasses. And one of our cases, a guy has been in prison for 22 years, and the main plank of the evidence against him, we found, is somebody who gave testimony that he gave a self-confession, and in reward for that, actually got released 8 years early from his own sentence for raping an 84-year-old woman. So this is some of the stuff that you start to unearth when you start looking into alleged wrongful convictions and looking at established miscarriage of justice through successful appeals. But of course, we make the point that successful appeals are not evidence of innocence, right? Successful appeals are evidence that a conviction is deemed to be unsafe, and that can be for a variety of reasons. There could be something that went wrong in terms of how the evidence was obtained. If the evidence was obtained unlawfully, then you can show that, you'll have your conviction overturned. If you can show that any procedures or the judge misdirected in law, they're also good ways of getting your convictions overturned. But that doesn't prove that you're innocent. So the reason why we start off with these successful appeals is to just give an insight into some of the flaws with our system, some of the practices that are going on within the process of criminal justice, and to establish that these are some of the things that innocent people can fall prey to. Of course, one of the things that we're always, I suppose, accused of or asked about is, how do you know they're innocent? You're the Innocence Projects, you're just do-gooders, you just believe everybody who says they're innocent is innocent. That's the kind of very common thing that people say to us when they first hear about the work that we do. But I think that one of the main contributions that we've made is that we have made clear, we've started to ask a set of questions that people have never asked before. As things stand, a prisoner maintaining innocence who's in prison is always deemed to be a denier. You have been convicted by a court, you're guilty, you're in denial. So the prison system and the parole board always work on the basis that everybody who says they're innocent is in denial and don't take any account of the possibility that they might be innocent at all. On the other side, these grassroots organisations that have sprang up, Merseyside Against Injustice, the organisation Innocent, South Wales Liberty, South Wales Against Wrongful Convictions, Falsely Accused Carers and Teachers, all these groups, they all emerged around a particular claim of innocence or a particular claim of wrongful conviction. And they tend to be set up by family members, sons, mainly daughters, mothers, and they believe the person who's saying they're innocent is innocent. And the elephant in the room is that nobody ever asks that question. Well, we do ask that question. Because we're academics, we're in universities, we are training people to be lawyers, and they're not our sons, they're not our brothers, they're not our sisters. So one of the first things that we started to do when we were asked to send cases to other universities was to ask that question. Tell us as much information as you can about your claim of innocence. We started to ask questions about the elephant in the room that nobody had ever asked before. The system doesn't want to ask it, because it may undermine confidence in the criminal justice system if they find out that someone in prison is innocent. And the families didn't want to ask it because they wanted to believe their loved ones were telling the truth. And what we found was, there is a debate about this, some of the grassroots groups don't like me saying this, but what we found is overwhelmingly that people who are maintaining innocence are not innocent in the way that we understand it. We're talking about, we want to work on cases where people may be factually, actually innocent. Not technically innocent or legally innocent, it's factual innocence. So what we found in this research was, when we did some research on the reasons why people say they're innocent, is that there are gross misunderstandings of criminal law out there. People don't understand joint enterprise law. So they go on a crime with others, and then if somebody gets hurt or injured or killed, they say, I didn't shoot, I didn't stab, I didn't push, I'm innocent. And we say, well, you may be factually innocent in that strict sense, but you're legally and morally culpable, and we're not working on your case. People often just disagree that the criminal offence that they've been convicted of is or should be a criminal offence. Oftentimes they say, you know, I've been convicted for having consensual sex with a 15-year-old girl. In my country, the age of consent is 12. I'm innocent. Your legal system's wrong. Animal rights campaigners, people who are anti-war protesters, they don't think that the criminal damage that they do should be a crime or is criminal. They think it's a moral right. They think that it's in the interest of justice. And they claim innocence and say they shouldn't be in prison, like political prisoners. Another case of people, a final one, is people maintain innocence to protect loved ones from the stigma of being associated with a criminal. So the case we've got, we haven't got much evidence on this, but we've got a lot of suspicions, but we do have one concrete case of a guy who is a career burglar, and he swore to his mother he would never commit another burglary. And then he was caught, when he came out of prison, then he was caught again. So his mother said, you told me you wouldn't do this again. Ma, I've been fitted up. They don't like me. They're using previous convictions to convict me. I wouldn't lie to you, Mum. 10 years he maintains that position. The prison system, the parole board, are saying he's a denier. When his mother dies, he tells the truth. I want to do my courses now. I want to do my offending behaviour courses. But you're innocent now, not? I didn't want my mum to know I'd lied to her. I'd rather be in prison and my mum thinking I didn't lie to her than actually get out of prison and she know I lied to her. So there's a real, in a sense, social psychological phenomena there, but that person's not in denial in the way the prison service and the parole board understand it. It's a social thing, it's a social relational thing. But the reality is, because of the flaws of the system that I outlined a few minutes ago, that some people who are saying they're innocent may be and are through the work that we're doing. They say that they were not there at all. They were in a different country. It wasn't them. And they're the cases that we select to work on. One of the cases we show here is the Cardiff 3 case. We talk about Sean Hodson case. We give information about those cases. People who have been shown to be factually, actually innocent with DNA. And that's a lot of the work that we now do. So we established the fact that these people were wrongly convicted. Hodson's been in prison for 27 years until he can prove that he's innocent with DNA. Fascinating case, if people are interested in cases. Sean Hodson, 27 years ago, 29 years ago now, he's been out 2 years, he's convicted for the murder of a woman called Teresa de Simone. And the only evidence against him was some blood grouping. So they just found some blood, and he was the same blood group, and then he confessed to the murder. He was a known fantasist, he'd confessed to lots of crimes he'd never done, and that was enough to send him into prison. A year after Hodson's in prison, a guy called David Lace comes forward, and he claims that he killed Teresa de Simone, and he couldn't live with it on his conscience, and he also felt pretty bad that another guy is in prison for his crime, i.e. Sean Hodson. The police told him to go away, whereupon he went and committed suicide, and he left a suicide note saying what he'd done and how bad he felt. His mother took up the campaign, she wasn't listened to either. 27 years later, they found some samples, I won't go into it, they'd always been denied to exist. It took 12 years to find them, but they did exist. They tested them and it proved that the full DNA profile, there was a full DNA profile and it wasn't Hodson at all. So Hodson overturned his conviction because the evidence against him at trial was unreliable. But there's no acknowledgement that he was innocent. So Hodson carried on saying he was innocent, and then something quite spectacular happened. David Lace's body was exhumed, whereupon they found that he was a full DNA profile match with the person who killed Teresa de Simone, because she'd been raped, and there were semen samples, and it was his. You'd think then that the system would acknowledge that a factually innocent person had been killed, but they didn't. Because what happened in that case is, a spokesperson for the Crown Prosecution Service said, this does not mean that Sean Hodson is innocent. All it means is, had David Lace been alive, there'd be enough evidence to think about charging him for her murder. So they won't even admit he's innocent now. As I've said, we talk about the parole deal. I've already kind of made mention to the parole deal. That, you know, this is, in prison, you're required to admit your guilt, comply with your sentence plan, do specified offending behaviour programmes to show that you've reduced your risk of reoffending. Prisoners maintaining their innocence won't do that. Because, and it's not just about, you know, about they don't want to admit to something that they say they haven't done. They're told by their lawyers, if you admit that you committed that crime and do those courses, you'll never ever overturn your conviction. So they're kind of getting it from all sides. You know, they're being put, there's pressure come from prison psychology, from prison officers and the parole boards to kind of comply and to admit to things that they say that they didn't do. But their lawyers are telling them on the other side, and their friends and families and parents, hold strong. Don't admit to something you haven't done. So they find themselves in this catch-22 situation. And we've got lots and lots of stories about people who've just wanted to get out of prison and say, you know what, I actually don't care if people think I did this crime. I've been in prison 20 years now, I've got to get out. And they want to say that they did these things. So they say, I want to do the offending behaviour courses. So they get on some of these offending behaviour courses, and they require, especially things like the sex offender treatment programme, a full and frank account of your crime. And that's where they fall down. They can't give a full and frank account of something that they didn't do. So what happens then is, they really seem to be dangerous offenders, and they are probably unlikely to ever get out unless they overturn their convictions on appeal. And in terms of the cases which we've deemed to be eligible at the Innocence Network UK to send out to other Innocence Projects, the longest serving person's been in prison now 42 years maintaining innocence. If he'd have admitted his guilt, he would have actually come out after 10 years. So he's been in prison more than 30 years longer than if he'd have been a guilty offender. And there are cases like Paul Blackburn, Robert Brown, both of whom were in prison for 25 years, and had they admitted their guilt, they would have actually come out after about 10 or 12 years. But prisoners maintaining innocence get blocked in the prison system, they get buried in the prison system, and often, well, they can't come out unless they overturn their conviction. So that's kind of where criminal procedure comes in. So this little book gives 4 chapters about how the criminal justice system, how the criminal appeals system tries to deal with alleged wrongful convictions, claims of innocence. So we talk about, there is some information actually for how people who are convicted in magistrates court might go about trying to challenge their convictions, because there's a lot of injustice at that level. But the cases we work on are all people who are convicted in a Crown Court. So we give information about how you overturn a conviction given in a Crown Court by taking it to the Court of Appeal. We talk about judicial review, we talk about the Supreme Court, we talk about the Criminal Cases Review Commission, and we talk about the European courts and the role that they can play. I won't go into all of the detail, but the problem is the same, whether it be with the Court of Appeal Criminal Division, the Criminal Cases Review Commission, or the European courts. What they're actually looking for in terms of trying to overturn an alleged wrongful conviction is fresh evidence. They want fresh evidence that wasn't available or could not have been available at the time of the original trial. You'll all know about the doctrine of finality. You know, you get one bite of the cherry. You get one trial. You can't just keep bringing different grounds in different trials. So what happens is that people are required to put their best case at their trial. If you're thinking about it in terms of a game of cards, you try and play your best hand first. You can't hold any cards back, because if you try to hold some cards back and you bring it to the Court of Appeal and say, well, I have this evidence that shows I'm innocent, the Court of Appeal says, you've had an opportunity to actually bring that evidence in your trial and you chose not to, for whatever reason. So, you know, there's no real interest in those cases, and they get turned down. On some levels, that's fair enough. You know, we can't just have endless trials after trials after trials. So we understand the logic of it. But when you look into these allegations, what you often find is tactics by their defence teams not to call certain witnesses or not to investigate certain matters, and the person who bears the brunt of that is the client. Now, there are real issues there, because by and large, the people who we're looking at, pretty much everybody, they were all represented by people on legal aid. They're represented by people who weren't very experienced. People being convicted of murder by a solicitor they met in a police station, a duty solicitor, who then goes on to represent them in their first murder trial and say to their client, I haven't done a murder trial before, but I've just been looking back in the textbook from when I was at uni. And what it says is that the prosecution has to have evidence beyond a reasonable doubt. And I'm going to argue for you that I think there are a few doubts. So I think you'll be all right. And then they get convicted. Because what we find in the cases we work on is that all of the resources are on the prosecution side, on the police investigation side and the prosecution side. And there's very, very little resources on the defence side. Because we've been thinking about the presumption of innocence and how it actually plays out in reality. You know, we've got this idea that the presumption of innocence and the burden of proof on the prosecution is a good thing, haven't we? It's a protection against wrongful conviction. Would you agree? Well, if you'd agree, you'd be wrong. Because the way we're trying to understand this now, that in theory, the presumption of innocence looks fine. But when you start thinking about how that works in practice, it's the wrong way around. Because what happens is, if you are presumed to be innocent, you are rendered passive. And if the burden is on the police and the prosecution to get evidence to prove beyond a reasonable doubt that you're guilty, what that means is that they have the burden. A burden's not a good thing. They're burdened to prove guilt. So all of the legislative framework is in the interests of reducing the burden and helping to establish guilt. So the erosion of the right to silence under the Criminal Justice and Public Order Act, you know, silence now can actually be, you know, an inference of guilt. Well, how can that fit with any straightforward understanding of the presumption of innocence? If there's no evidence against you, and the only evidence against you is that you're remaining silent, how can someone be convicted on that? And we see in our cases that people remain silent in police station interview, no comment, no comment, no comment, that people do not give evidence in their own trials because their lawyers are telling them, you don't need to make any comment. It's up to the other side to prove you are guilty. But in a courtroom setting, no comment interviews to people accused of killing their wives and not giving evidence to even tell the jury, I didn't do it, I loved her, she's the mother of my children. It doesn't sit well with people in a jury. It looks suspicious, it feels wrong. And without any other evidence, just a bit of bad character evidence or a bit of hearsay evidence about a supposed motive, they get convicted of murder. And that's what you learn when you do the Innocence Projects work. You look at that. You look at how legislation actually facilitates reducing, minimising the burden on the prosecution. Whereas we're even thinking now that people may be better if we have a presumption of guilt. Well, not a presumption of guilt, but you start from a position of possible guilt. Because that's what the Innocence Projects do in practice. We get a case of someone who's been convicted, lost an appeal, CCRC have said no, they're guilty. And what we do is we put all our efforts into trying to find out whether or not the evidence that's indicating that they're guilty stacks up. And you know what? A lot of the time it does. And in the last 6 weeks we've told 2 people that they are guilty in cases that we've investigated for several years, and we've told them why they're guilty. And you know, it's not always the case that you're going to be able to knock the evidence down, but you interrogate it from that perspective. And oftentimes, as I said, for other cases, such as Simon Hall and Neil Hurley's case, we believe that there's serious doubts there and lots of evidence of possible innocence. Say just one point on the Criminal Case Review Commission before I hand over to Gabby. The Criminal Case Review Commission was set up, as far as the public were concerned, to assist with people who may have been innocent to overturn their convictions. The public crisis of confidence in the late 1980s, early 90s, around the Birmingham 6 and Guildford 4 cases, was not a public crisis of confidence in terms of we think these men may have been wrongly convicted on a technicality and we want them to get their convictions overturned because they may be unsafe in law, because they were tortured and all the rest of it. The public genuinely believed that these people were innocent. And if you read Chris Mullins' book about the Birmingham 6, he tells you there who did the Birmingham bombs. He doesn't name him, but he goes into chapter and verse about who did it and how he knows who did it. If you look at Jerry Conlon's book, Proved Innocent, the Balcombe Street gang accepted they did the Guildford and Woolwich bombs, but yet that was denied. So the public crisis of confidence was that we wanted a new body. We couldn't trust Home Secretaries, politicians, to have this authority, this power of referring potential miscarriage of justice back to the courts, because they kept refusing to send these cases back because they didn't want the political embarrassment. So we needed something which was independent of politics. We needed something that was impartial to look at these cases, and that's what everybody thought the Criminal Cases Review Commission was. The problem is that when you look at the statute, they set it up, the Criminal Appeal Act 1995, in detail, it was set up contrary to the Royal Commission on Criminal Justice's vision for what it was supposed to be, because it is not independent. Because whereas the Court of Appeal is looking for fresh evidence, the Criminal Case Review Commission is looking for fresh evidence. Because any evidence that was or could have been brought to a previous appeal, because you've got to have failed an appeal before you can get to the CCRC, can't be used at the CCRC stage. So we've got a case which is available on our website, a case of Neil Hurley. 3 times Neil Hurley has been refused by the CCRC, and we've just made a 4th application for him. Because in 3 applications, were you going to talk about Neil? Yeah. I won't say anything about Neil, because otherwise Gabby will have nothing to talk about. But the point is that in terms of the logic of how the CCRC understand things, Neil Hurley now requires not fresh evidence at the Court of Appeal stage, but fresh evidence, fresh evidence. That's where we are. The tunnel gets narrower and it gets harder and harder to overturn these cases. But there is lots and lots of evidence that may be able to prove whether or not Neil Hurley is telling the truth when he says he's innocent. Now, I'm going to hand over to Gabby to talk about, that's the first 2 parts of the book. The first part is establishing the problem. The second part is actually going through criminal procedure and saying that even though for the large part it can deal with innocence claims or claims of alleged wrongful conviction, there are still cases it can't deal with. And so that's where we come in. So we're coming in now to try to establish a method for how you might go about proving your innocence. Just quite briefly, after the methodology section, what we are saying is that there's been quite a lot said, a lot of critiques made about lawyers. When we give examples about why someone might be innocent and may not be able to establish grounds, we often make reference to tactics or decisions made by lawyers for which the client, the alleged innocent person, has to take responsibility for and pay the price for ultimately. So we also talk critically in this book about using solicitors, and we also talk critically about using Innocence Projects, because the reality is that not all solicitors are the same, not all Innocence Projects are the same. And we want to kind of start to put that out there. Different Innocence Projects do different things, and most lawyers are doing desktop reviews of claims of innocence, and they're not investigating the claim of innocence in the way that we've said. Because just if you're looking for fresh evidence, you're not going to look in the unused evidence, because by definition there's nothing fresh going to be found there. so they don't even look in it, and they're not paid to look into it. So what we're saying in this book, when we're speaking to prisoners, those trying to help prisoners, including Innocence Project students, do due diligence on the solicitors that you're going to get to help you. One of the articles on the Innocence Network UK website asks, can lawyers put people before law? And I'd invite you to have a look at that as well, because reflecting on 5 years with the Innocence Project, you know, a lot of you guys want to go into law, maybe not criminal law, but you want to go into law. And when the lawyers come and work with the Innocence Project, they're telling the students, don't bother looking in the unused evidence, because, you know, you're not going to find anything fresh there. And it's, in a sense, it's jeopardising this whole kind of project. Because what we say to the students at Bristol is suspend this obsession with trying to find legal grounds for the time being. Let's look into this in terms of a truth claim. Someone's claiming that they're innocent. You know, we're doing this pro bono, we want to do social justice, and we want to try and help someone to overturn an alleged wrongful conviction. Look in the unused evidence, because I believe, and I'm yet to be proven wrong, that if you put the evidence of innocence in front of somebody, any lawyer, that they will be able to make that into legal grounds. But you won't be able to do that if you don't go looking for it. And it was looking in the unused evidence in Neil Hurley's case, as I said earlier, 3 times refused by the Criminal Case Review Commission, and 3 times nobody had ever noticed, because he hadn't noticed it himself, because this evidence wasn't used against him at trial, that there were over 120 exhibits from the crime scene that have never been subjected to any testing. But the CCRC aren't actively investigating a claim of innocence, they're reviewing to see if your conviction's safe in terms of the applications that you made. And as Gabby said, time after time after time after time, we see applications to the CCRC with just one line. What is fresh? Or one of the witnesses is retracting. But there's 15 witnesses against you. How is that going to persuade anybody? But what we're finding is, you know, we're saying you can actively do some new testing. We've put a checklist in there for people to actually use when they're trying to determine whether or not the solicitor is the right kind of person you want to be working with. And we've put a checklist in there about what kind of an innocence project that you actually either want to belong to, or what an alleged innocent victim of wrongful conviction may want to work with. And the final thing in this is just to kind of return to this central issue about innocence. And we're talking about, there's a lot of misunderstanding about what Innocence Projects is. I tried to explain earlier that we're talking about factual innocence. But often another thing that we're actually claimed, another kind of criticism of us is, you think that, you know, you are judge and jury. You think that you can second guess if someone's innocent. And they think that, and what I'm trying to kind of put out here, is that if we work on a claim of innocence and completely discredit all of the evidence that indicates that they're guilty, we regard that person to be innocent. Because where is the evidence that they're guilty? So as Gabby said, we try to do 2 things: interrogate the claimed evidence of guilt, but actively then, like in cases like Simon Hall and cases like Neil Hurley, we've done both. Knock down the evidence and provide evidence that could prove innocence. But we've got some, there's a lot of problem when people overturn their convictions because their conviction's unsafe in law, because we don't give appeals easily in this country. You've got to completely discredit all the evidence against you. But when people do that, and they overturn their convictions because they're deemed to be unsafe, they continue to be thought of as possibly guilty, because they haven't got a declaration of innocence. And recently, you've got Sean Jenkins and you've got Barry George in the media. Barry George convicted for killing Jill Dando, TV presenter, and they're trying to get compensation for their wrongful convictions and wrongful imprisonment. But they're being told by the Home Office assessor, you are not eligible for compensation because you need to show that you are clearly innocent. So what's actually being asked for is evidence of factual, actual innocence, even though the Court of Appeal has overturned their convictions, even though some of these people have spent many, many years in prison. Michael O'Brien of the Cardiff News Agent 3, he spent 11 years in prison, he overturns his conviction, he gets one of the biggest compensation payouts there's ever been, he gets £1 million. But 10 years later, last year, he's on national television doing a lie detector test to prove the court of public opinion, you know, a bit Jeremy Kyle-esque, that he's innocent. He passes it, but people then say, reverse logic, ah well, they're not reliable, those lie detector tests, so you're probably still guilty anyway. But that's how desperate he is for people to believe he's innocent. And what we're trying to just conclude with is to say, and this is, I think, particularly important in the criminal justice system that's just abolished double jeopardy. So now you can be tried for the same crime twice if there's evidence that shows that you did it. That if someone overturns their conviction by showing that all of the evidence that indicated that they committed this crime is unreliable, is whatever term you want to call it, unsafe, they should be regarded as innocent until such time that there is reliable evidence that shows that they're guilty. Because once you have been stained by, you know, once the criminal justice system can take away your innocence, you know, you can be accused of a crime that you didn't do, but unless you can actually prove you didn't do it, you can be accused of a sexual offence of one of your students, whatever, and there's always going to be doubts about you, there's always going to be whispering campaigns about you, and sometimes you can never actually prove that you didn't do anything, because false allegations occur. So what we're saying is that the criminal justice system can take away innocence, but very, very rarely can it ever be restored, like the case of Sean Hodgson, as I talked about earlier, and even in that case, they're resisting it by saying it doesn't mean he's innocent. It just means somebody else could be charged for it because he might have participated in the crime with the other guy. And as Gabby says, just because it's not his DNA doesn't mean he's innocent. So it's a really interesting area of pro bono work if people are interested in it. It's not short-term work. You know, we've made reference to, we've worked for several years on all of these cases. And the experience in the United States is the average time it takes to overturn a wrongful conviction, even in a project that only uses DNA testing, is about 8 years. So it's groups of students, year on year, working together and passing the case on to somebody else. And that's the kind of teamwork and collaboration that Innocence Projects require. But you've got to be in it for the long haul. But you know, if you do want to get interested in this, it probably is one of the most fascinating and, you know, meaningful areas of pro bono work that you can actually get involved with. So thank you very much for your time.